all right? As a defendant's attorney, you got to know after the litigation, obviously, to find out if it was done. If you're lucky enough to have a client and be with him before accidents, pre-bid, then you want to tell him what kind of implementing program. The paradigm of a good safety program would start with a pre-bid meeting when bids are being let out, where the owner or GC explains what type of safety program is going to be required. And contractors should be required to submit written safety plans at such a meeting. Further, you can check out a contractor's safety record. Right? Contractors should have safety records for the prior 3 years. According to OSHA, there's a log they keep. It's called an OSHA 200 log, and it should list their safety record for 3 years. Within the contract itself, it should be stated, and you don't see them in these form contracts, really, not the one in the book in any event, but that safety is a condition of employment. All right? Then you can stop this recalcitrant worker from even staying on the job if he's not going to utilize safety devices. Following the pre-bid meeting, there should be a pre-construction meeting. Contractor's safety plan has to be reviewed and approved. It should include the following: a safety policy. And as a plaintiff, I'm going to ask them, what was the safety policy at this job? It should have a detailed safety program, and it should designate the contractor's safety representative. Okay? A general contractor or construction manager in the city, we're seeing more and more, instead of GCs, construction managers. You see a lot, you'll see Lyra McGovern, for instance, HRH are acting now as construction managers, and you don't see a GC on the job. I'll talk about it in a minute. As a practical matter, they're usually the same thing, as far as the labor law goes. But the GC or construction manager should have at least one employee whose sole job it is to be the site safety representative. So as a plaintiff, when I take a deposition of the construction manager, general contractor, I'm going to ask, who was the site safety representative? How often did you inspect the job site? Did you have other duties? Because unfortunately, when they designate these people, they give them a lot of jobs to do, and safety may be one of them. They'll walk around the job if he gets a chance. Right? That's the way these jobs are handled, unfortunately. Now, there must be a method of enforcing the safety programs, or once they've been designed, so that workers follow them. Otherwise, they're no good. Every worker should attend a pre-construction safety meeting where the safety policy of this particular job is spelled out to them. Weekly safety meetings of workers should be held, and weekly safety meetings of the safety reps should be held. Before any worker comes on the job, a site orientation should be held, and job hazard instruction given. And if you document it, think about this. If you have a 241-6 case and you're documenting, and those of you who, and most of you are defendants' attorneys, you take the depositions of the plaintiffs, and they've been hurt in what manner, and you say, well, did you know that was dangerous? Me? Nah, I didn't know. I mean, what do I know? I'm doing my job. I got to work. If I complained, I'm losing my job. What am I, that's the way they testify, right? And I didn't know anything about safety. What do I know about safety? I'm depending on them. They said to do it, I did it. If you have it documented that they've been given instructions, you say, well, wait a minute, what about this? You were told this, weren't you? I mean, so you get your culpable conduct in, all right? And that's so you keep a permanent record of it. The site safety inspector, certainly for the GC or the construction manager, as the case may be, should do regular safety inspections, and they should be documented. Scaffolding should be inspected, records kept that it's in a safe condition. Temporary protection should be checked, floor coverings and the like barriers along the outside of floors on open Sides of the building should be checked. If there's excavation, the shoring should be checked, and it should be documented. Finally, housekeeping. Many of you, I'm sure, have these trip and fall cases where debris is left around and people fall, and you're faced with a 241-6 with the general industrial code standard as to tripping hazards. So good housekeeping should be enforced. Passageways and walkways kept clear. Nails taken out. I'm sure some of you have had to step on the nail case, right? Clean it up a little bit. Adequate lighting. That's a basic model. It's not all-inclusive, but that's a basic model for the implementation of those contractual provisions, which really say nothing. I mean, it's almost like they're being written to say, okay, we did something about safety, but all it does is come back to bury the contractors because it's never carried out. So that it really should be implemented. So you as a plaintiff want to show that it wasn't implemented. Hopefully, as a defendant, you can show it was.